Good afternoon, everyone. I hope you're having a wonderful day. In answer to a question about sellers who do not complete after exchange, I did have a question from somebody who asked if there's anything that can be done if a seller pulls out at the last minute. As we all know, the law in this country permits a seller to pull out even on the morning of the exchange, leaving the buyers potentially thousands of pounds out of pocket. Consultation fees, application fees, surveys, searches, perhaps payment on account to a solicitor, etc., etc. And there's nothing that they can do. Or can they? There is case law about this. I assure you that the vast majority of solicitors are probably not even aware of this. The reason that I know it is purely by coincidence and an interest on my part. However, this is the case that was in 2019. It was Neocleous versus Rees 2019. The QC acting for Mr. Neocleous was Mark Coulson. The barrister acting for the defendant was Duncan Heath. Not a silk, expensive mistake. So, in brief, a landowner won a landmark ruling which proves you should always be careful what you put down in writing. Finance whiz Stavros Neocleous was furious when a neighbour went back on a deal to sell a piece of land adjoining his property on the shores of Lake Windermere, Cumbria. He argued that it had been agreed verbally and through a trail of email correspondence. However, the defendant then applied to have the right-of-way case relisted and stated that the terms of the sale of land had not been completed, which the claimant contested. So the claimant, Mr. Neocleous, agreed to buy this scrubland adjoining his land in Lake Windermere because it looked untidy and he wanted to buy it so that he could tidy the land up. And at the last minute, the seller withdrew. In brief, here is the ruling. Manchester County Court considered whether this email exchange constituted a contract for the sale of land. The judge, His Honour Judge Pearce, held that the two emails, which combined together to form an email chain, amounted to a single document which had been signed by the authorised agents of their parties by their automated signatures at the foot of each email. The judge also held that the presence of the defendant solicitor's name indicates a clear intention to associate oneself with the email, to authenticate it or to sign it. The defendant's solicitor also used the words "many thanks" immediately before where his signature would be produced, and this showed an intention to connect the name with the contents of the email. The court held that a binding agreement of compromise involving a transfer of land had been entered into and granted a finding of specific performance. I will be posting a link. I've written about this in an article on my website, and I have the full transcript of the case from the court. This is case law, ladies and gentlemen, from June 2019. And as I said, I assure you that 99.9% of solicitors, if you ask them but don't mention the name so they don't go and find it, won't know about it. Another point to note, Mr. Neocleous hired a silk. The defendant did not. If you are going to engage in something like this, do not bother with a novice barrister, because all they know is veggie burgers, Brexit, just stop oil, and what you can and can't say on Twitter. You must instruct a silk and do the job properly. There's no comparison between a silk and the rest, to be perfectly honest. It's no reflection to the rest, but when hundreds of thousands potentially of pounds, in this case, the defendant has to pay costs on both sides, and the costs for a silk are very, very high. So she will be selling the land and there will be hardly any change from the sale. So you need to be very, very careful who you instruct. I'll post a link to the article. It's got the full transcript. Basically what this means is if you agree to a sale in an email, it is binding. But I've not heard anything further since this case. In other words, I've not heard of any other solicitors use this as case law to take action against the seller who refuses to sell. So if you are a solicitor, I'd be interested to hear from you, because the feedback I get from people who have been let down by sellers is that the solicitor shake their head and basically said, well, there's not a lot that you can do. Well, this man said there was something that he could do, and there wasn't case law when he took this to court and he won. So this may be of interest to you, and if it is, read up the full details and approach with caution. If you have any questions, as always, you can contact me, email, phone, messages, although email is best so they don't disappear in the messages. Thank you very, very much for watching, and I'll see you next time. Bye-bye for now.